So in this video, we'll look at the fight to ratify the Constitution. So we'll start with a real quick recap of the Constitution itself and some of the big changes they made. So we looked at this in the last video, the preamble and all the important parts of it. If we look at the structure of it, and this is important to understanding why some people oppose it afterwards. There's Article 1 of the Constitution that describes the legislative branch. So we're talking about Congress, right? So this legislative branch will make the laws. They'd established a bicameral Congress, which, if you remember, means a two-house Congress. And one house would be the House of Representatives. So if we look at something, just to refresh your memories of the House of Representatives, it was determined by population, meaning the representation. So big states would have more members in the House than small states. So that way it was a part of that compromise, a great compromise to appease the big states. The people that serve in the House of Representatives will serve for 2 years. So every 2 years, everybody in the House runs for re-election. So that way they're more responsive to the people and they're directly elected by the people in the states. So that's important because the House of Representatives was supposed to be the house that was the lower house, more close to the people, so that every 2 years, people of the states would vote and their vote would directly go to deciding who was a representative. And if you have to get elected every 2 years, then you're more likely going to be listening to the people and doing what they want. The upper house would be the Senate, and we know that they created equal representation, so every state would have 2 senators. That way small states couldn't always get bulldozed by the big states. They served 6-year terms, which is a long time. This shocked a lot of people when they saw this. A 6-year term, 2 years longer than a president. A lot can happen in 6 years. You can send someone to the Senate, and they can start doing things that the people don't like, and in 6 years is a long time to remove them from that Senate office. But the founders thought that it was good that one house of Congress had continuity, right? That it wasn't changing every 2 years. Changing every 2 years can be good for the House of Representatives because it's responsive to the people. If the people in the House are doing things that people don't like, we can vote them out. But they thought one house of Congress ought to have people that are there more consistently. So therefore, they're not going to constantly be changing, always learning how to do the job. So they have 6-year terms. And the Senate was elected by state legislatures. So once the Constitution was written, people didn't vote on senators. So state legislatures, so like in New Hampshire, the state legislators in New Hampshire, up in Concord, they would choose our 2 senators. So you could argue that was indirectly impacted by the people because we would vote for the people to go to Concord to vote for state laws, and then those people who are representing us would vote for senators. But they didn't have direct election of senators by the people because if you remember, people like James Madison and John Adams distrusted the people for the most part. They wanted more of an educated elite group of people running the government. So they wanted the Senate to be somewhat removed from the people. That changed in 1917 when we passed an amendment so that now today we vote directly for senators. But it took all that time from 1787 to 1917 for that change to be made. So that's the Congress. We look at some of their enumerated powers. Remember, enumerated powers mean the ones that are literally said in the Constitution. Sometimes it's called the expressed powers. So one power to tax, right? So we know that the Articles of Confederation was weak because it couldn't tax. It couldn't compel states to pay taxes. This new Congress has the power to tax. It says literally in the Constitution that they can tax. To borrow money. So we know that that's an important thing for governments to do so they can fund wars, pay soldiers, pay for land, whatever it might be, they can borrow money. Congress has the power to coin money, the sole power to coin money. States can no longer coin money because we saw that was a problem. The Articles, now just Congress will be able to do that. They have the sole power to regulate international and interstate commerce. So all things coming into the country are regulated by Congress. That's international trade, trade with other nations, and interstate commerce, commerce between states. So states can still regulate commerce entirely within their own state. That's called intrastate commerce. But if there's something going between Maine and New Hampshire, or New Hampshire, Massachusetts, Congress has the power to regulate that. They have the power to raise and support armies and navies. They have the power to declare war. The power to establish rules of naturalization, meaning how do people become citizens? How long will it take? How many years? What qualifications do they have to have? What they have to pass a test? Congress determines that. They gave Congress the power to grant patents and copyright. So if you don't know what patents are, that's if you invent something, you have a new discovery, an invention, or a scientific discovery, you can patent it. Therefore, you can profit off of it. Copyrights essentially protecting your intellectual property if you write a book or a song. And they saw this is going to be important because they wanted the country to start establishing its own national identity for science and the arts. So it was important to protect those things. And there's other things in there too, like we go back to these implied powers, these express powers. There's other powers in there. These are the main ones that I'm talking about. You can look in there. There's several other ones, but when we say the enumerated powers, those are the powers literally that it says in the Constitution. But they left a loophole open called the necessary and proper clause that we also can call implied powers, meaning that it doesn't actually say some things that Congress can do, but it kind of implies that Congress can do other things. And it comes down to this clause that we call the necessary and proper clause, that Congress has the power to make all laws which shall be necessary and proper for carrying into the execution of foregoing powers, meaning the powers that we just talked about, the enumerated powers. You can make other laws that are necessary and proper to carry out any of those powers, and all other powers vested by the Constitution of the government to the United States or any department of the office thereof. So you think about what this means, that there's all these powers that we looked at before, right? These enumerated powers, that Congress has a power to do these things, but if they have to do something else that's necessary and proper to carry out some of these powers, they can do other things. That's a necessary and proper clause. So you think about this necessary and proper clause, that's going to be used to expand the powers of government throughout history. We'll see this early on with the National Bank. That's something we'll study next year. It doesn't say in these enumerated powers that Congress can make a bank, but it does say that Congress can regulate currency, it can borrow money, and it can tax. So people are going to make an argument in Washington's presidency that it's necessary and proper for the government to create a bank so it can collect taxes, borrow money, and coin money. Same thing with the Commerce Clause, regulating interstate commerce. That's going to be used in the 60s, in the early 20th century, to strike down segregation laws. And if you look at these laws, these powers, it doesn't say that Congress can regulate segregation or racial relations or anything like that. But they're going to say later on that in the 60s, in the 50s, that if business people want to travel from the north to the south, say from New York to Georgia, and they can't stay at a hotel because they don't allow African Americans, then it interrupts commerce. Therefore, it's necessary and proper for Congress to end segregation in hotels because it interrupts commerce. So that's something we'll study. We'll see those things next year. But I think the big point is here is this necessary and proper clause greatly expands the power of government without actually saying what it's going to do. It just leaves an open door for the government to do other things. Sometimes they call this the elastic clause because it stretches the powers of government. So that's Article 1. Article 2, if you remember, the presidency, right? Their job is to enforce the laws or execute the laws. They decided on one president. That president would serve 4-year terms with no term limit, right? We have a term limit now, but when that didn't happen until the 1940s. As a constitution was written, the president could run for as many terms as he wanted to until people didn't vote for him or he decided not to run again. The president, remember from the last video, is elected by the Electoral College, right? Not directly by the people because they feared that the people might choose a demagogue, right? A bad leader. So they wanted the president to be somewhat insulated from the people. So they elected by the Electoral College. The powers they give to the president: enforce the laws, veto laws if they don't like them, commander-in-chief, that's a big one, a civilian control of the military. The president has the power to negotiate treaties, but then he has to give it to Congress to ratify the treaties. But the president can negotiate the treaties. They can appoint heads of executive departments, federal judges, and ambassadors. In all these positions, department heads, judges, ambassadors, they have to be approved by Congress. But the president has the power to nominate them, right? So there's some powers given to the president. And if we look at the last branch, the judicial branch, in more detail, this is the Supreme Court. They interpret the Constitution and whether the other branches will follow it. This is what we call judicial review, right? So if judicial review means that the Supreme Court has the power to overlook the other two branches and decide whether they've acted constitutionally. And if they didn't, then they can strike down things that they did. So if Congress passed a law that was unconstitutional, the Supreme Court could rule it unconstitutional, and then therefore it's invalid. If the president or the executive branch did something unconstitutional, the Supreme Court could rule their actions unconstitutional. That's called judicial review. The judges can review other branches of government. So that's the main function of the Supreme Court. Federal judges serve life terms. So that's going to be a complaint to the Anti-Federalists later on. These judges, once they're appointed and approved by Congress, they can stay judges until they die or retire. The only other way to get rid of a judge is to impeach them for committing crimes, but you can't get rid of a judge just because you don't like them. If they're too liberal or too conservative, they're there for life until they decide to retire and step down. They gave, the president appoints the judges, confirmed by the Senate. So there's a little bit of separating of powers there, right? So one branch, both the other two branches have to agree on the judges. Congress determines how many Supreme Court justices there are. In the first Supreme Court, they had 5. Now it's 9. They expanded it. They could even today they can make it more or less, right? That's left to Congress to decide how many justices we have. And Congress can create lower federal courts, right? So the Constitution only creates a Supreme Court, and any other courts, federal courts, Congress had the power to create. So this is our judicial branch. So that's a quick review of our Constitution. When they present this, you think about this, all the people that were at the Constitutional Convention in the summer of 1787 were there, and by September, they had enough of the delegates that agreed to the Constitution to sign it, right? They had enough of the majority of the people, of the delegates, to take it to the people and let the people in the states vote on it. And the reactions to the people, you can imagine, were extreme. Some of them said, wait a second, you said you were going to go and you were going to revise the Articles of Confederation, and now you don't even have that. You scrapped it altogether, and you've given us this new government that is much more powerful and doesn't look anything like what we thought it was going to look like. In fact, some of them thought it looked a little bit maybe suspiciously like the British government in some ways. So some people hated it altogether. Other people had a different reaction where they thought about it as, oh, wow, this is different, but we like it. This is much more powerful. This is going to be a much more stable government. So I think people that wanted the nationalists that wanted a strong national government were very happy, almost pleasantly surprised by the government that came out. So the next task of the country then was to bring it to the states and convince people to ratify it. They needed 9 out of the 13 states to ratify the Constitution. So it's almost like an intellectual battle that rages afterwards between the Federalists we see here and the Anti-Federalists. So you think the federalism, again, is a sharing of power between the national government and the state governments. But the Federalists supported a stronger central government. That doesn't mean just a central government. They still wanted power in the states. They still wanted states to have, things that only they could do and then some powers they would share. But they saw the need for a stronger central government after all the failures of the Articles. So the Federalists favored a stronger central government. They saw the need, particularly for the power to regulate trade and tax, right? The two of the great weaknesses of the Articles. They believed in national supremacy, that when, if you remember from the last video, if the national government and the state government has conflicting laws, the national government wins. They saw the country that doesn't have a supreme national government is no government at all, right? You might as well just be 13 separate states. So they believed in national supremacy. Where you can see this on the map here, where there tended to be Federalist support was in coasts, towns, and cities. And if you look at the map in green, most of the coastal areas, those are merchants. Those are people that want protection against unfair international trade. If you're a merchant in Massachusetts, you don't want the British to be able to go to New Hampshire and get better trade deals. You want one unified trade policy for the country. So coasts tended to approve that. Cities and towns where population centers were tended to like the Constitution. As far as occupations, merchants, businessmen, and generally speaking, the wealthier people, the more well-off people, and that includes planters as well as merchants and wealthy businessmen and bankers up north. They tended to favor a strong central government to protect their property, to protect their rights and their livelihood. Think about who some of our strong Federalists were. We have Alexander Hamilton, one of the main Federalists. James Madison, sometimes called the father of the Constitution because a lot of it was his work. John Jay, future Supreme Court Justice, a strong Federalist. George Washington, I mean, he's the most important guy to get, right? He's like, he's the goat of the founding fathers. So if you have him on your side, that's a good thing. John Adams from Massachusetts, future president, and Ben Franklin. So this is a pretty heavy-loaded group of people, the Federalists, that are supporting this. Opposing them were the Anti-Federalists. You think about the term Anti-Federalist versus the Federalists, right? Federalists, just the fact that the Federalists took the name Federalists says a lot, and it's almost like you can think of it as a good public opinion or a propaganda kind of move on their part, right? To sway or a way to spin it. I mean, how can you be afraid of federalism? They're not calling themselves the monarchists. They're not calling themselves the strong central governmentists. The Federalists, a sharing of power between the federal government and the states that seems very seems very mild. When we look at the Anti-Federalists, they get in a sense actually get labeled by the Federalists. I mean, you think about that name, they're not called something positive. Their whole group of people is based on a negative. They're Anti-Federalists. They don't like sharing of power. So that was a big, you might think, public opinion win by the Federalists, just coining the terms Federalists and Anti-Federalists. These people, though, preferred stronger state governments, right? They didn't like the more power going to the federal government. They wanted a revised Articles of Confederation with some small changes, the power to tax, maybe the power to regulate trade. They didn't like the presidency, or they didn't like the senators, or whatever it might be. There's lots of things they didn't like, that they feared that they gave too much power to the federal government. They also demanded a Bill of Rights. When the Constitution was done, a lot of them you'll be reading about in the Federalist Papers and the primary sources, that some people said, where's the Bill of Rights? Where does it say specifically what my rights are that can't be infringed upon? So we need to have that, right? Because if you don't have that, how do we know when our rights are being violated? They typically ended up being poor farmers, illiterate, and people from the backcountry. And you see in this map shown in purple, right? People living further away from the coast and the population centers in the cities. New York, you can notice, is a very strongly anti-federalist state, with the exception of Long Island. But most of the other people are towards the western frontier. Now, it doesn't mean all the anti-federalists were poor and illiterate, because some of the great anti-federalists were people that we know. Thomas Jefferson, picture there, right? This is the guy that wrote the Declaration of Independence. He feared a strong central government. He said, we need a government that is for the people. You know, all men are created equal. Well, you think about he wanted a government for the people, meaning like, well, not women and not African Americans and not Native Americans. He meant the common white man is what he was referring to. But either way, he didn't want a government by the wealthy elite. We have people like George Mason, who you're going to read some stuff on the primary sources, some objections he has. Sam Adams, we know Sam Adams from Boston, right? So he's one of the Sons of Liberty, one of the people there from the beginning that started this whole thing. And he's not for the Constitution. He's an anti-federalist. Patrick Henry, guy says, give me liberty or give me death. Another guy, right from the beginning, one of the strongest of the patriots, is suspicious of this new government, doesn't want it put in place. So there's some big, heavy names here we have for the anti-federalists. And there's other ones, too. I don't have a picture of him here. Richard Henry Lee. He's the guy that proposed the first Declaration of Independence, the resolution that they wanted to break away. You know, he was against the Constitution. There's a lot of suspicion about how much power this federal government's going to have. And it comes down to a sense, somewhat of a propaganda war after the Constitution is released to the people. And we have these people, Alexander Hamilton, James Madison, and John Jay, these people that write the Federalist Papers, a series of 85 essays that they published in newspapers, primarily in New York, but then spread around the country. That are some of the most brilliant, it's one of the most brilliant accumulations of political thought there is. Throughout these 85 essays, they defended all different parts of the Constitution. Every time someone objected about one thing, they brought up something else. Said, oh, well, you know, here's an answer to that objection. This is why you have no reason to fear. The Federalists, think about this group of people that were well-funded and well-organized, right? Unlike the anti-federalists, who didn't really stand for anything, they just stood against something. These people had, something to fight for, something to rally behind. They were, generally speaking, some of the wealthier people, so they had more money to pay for editorials, to buy their way into newspapers. They're more organized, whereas the anti-federalists were just kind of, a bunch of people objecting to it, but not an organized group of people. If you look at some of the big Federalist Papers and the ideas, and you're going to read about some of these in your primary sources, Federalist number 10 by James Madison, he addresses the issue of faction and the size of the republic. Some of the anti-federalists were very afraid that they looked at democracies throughout history, like Pericles' Athens and the Republic of Rome. He said one of the things that has always killed democracy is faction, meaning people being divided. And you think in a small scale, that's true, right? Now, if you think of it, if you had like a group of the size of like our school, like St. Thomas, 400 people, it'd be easy for people to, almost like to pick sides and then be in rival factions, people that want to do one thing versus another. When they said that that's a problem for a republic, we can't have that. A small group of people would have a huge influence. James Madison says, no, that's not a problem at all. We're going to have a big republic. It's going to be vast. It's going to be so diverse, one person couldn't have that much sway over that many people. And essentially what he's talking about is political parties in some ways, and we know that that ends up being the case. But James Madison defended, saying, no, in a vast republic, there's so much diversity that we're going to have the best of the best representing us, and even if the majority wants to do something that's bad, their representatives will go against it. If you think about majority rule, we talked about that in the Enlightenment a bit. A problem with majority rule is that if 51% of us want to take away the property of the other 49%, well, then we can do it because we voted on it. But what about the rights of that 49%, that minority? Well, James Madison says, well, the Republic, we don't have that problem because we're less likely to be prone to that problem because we'll have educated representatives. They're going to be patriotic. They're going to put the country first before themselves, and they'll look out for the rights of the minority. Federalist number 54, separation of powers. Madison, again, very skillfully defends that, this government's not too powerful. Congress isn't too powerful because the president can veto their laws. The president's not too powerful because Congress can override his vetoes. The Supreme Court is the weakest of the branches, and it can check the other two. Some of the objections people had, they said, senators, that's like a life term. He says, well, yeah, but the senators are serving 6 years, but the House is reelected every 2. So that will be the check on the Senate. The Senate can't do anything without the House of Representatives. So he just very skillfully goes through all these objections and argues that this government is an answer to the problems that they see. They talk about Federalist number 70. You read about that. Alexander Hamilton defends the executive branches. It's not too powerful. We need a powerful executive branch to carry out these laws, to carry out the will of Congress and the will of the people. So you'll be reading about that. And then in Federalist number 78, he defends the judicial branch because a lot of people said, wait a second, these judges serve for life. We don't have a chance to unelect them, get them out of office. He says, no, we need a branch that's not political in a sense, right? The Supreme Court is separated from the other branches because they're not elected. Therefore, they're not going to do, you think if they were elected, they might make decisions based on getting reelected, right? They don't want to make people upset if they have to get voted into office. That by not being voted, once they're put into the judicial branch, they're there for life. They can, in a sense, judge with their conscience based on the Constitution. They don't have to worry about political pressure. And then they talk about the Bill of Rights, and you'll read about that. Alexander Hamilton says we don't need a Bill of Rights. The Constitution itself is a Bill of Rights. So you'll read some more about that. But these are some of the big arguments that they make, and these are very influential. There's anti-federalists, you might say, essays that get written and opposed to them, but these are much more influential, and they really help kind of sway enough people to vote for the Constitution. When it goes to the states, all the states have to vote and approve this, and again, 9 out of the 13 states have to ratify the Constitution for it to take effect. And we see these cartoons, actually, that we'll see in a sequence here, is an example of how well organized and funded the Federalists were, that they could publish things in papers because they controlled a lot of the newspapers, and they could, in a sense, dictate the tone of the story. When we look at these pillars of the government, we have the states there that vote to ratify the Constitution. On the far left is Delaware. Have you ever seen a Delaware license plate? Some of them say first in the nation, meaning they were the first in the nation to ratify the Constitution. So they ratified it. Then Pennsylvania, then New Jersey, then Georgia, then Connecticut. And you see Massachusetts isn't quite standing upright yet. And they see almost like the hand of God trying to will it in there. Massachusetts was a hotly contested state for ratifying the Constitution. Most people in the Massachusetts Assembly were anti-federalists, including, again, Sam Adams, John Hancock, some of these big leaders that people look to. And they feared that it gave them too much power. And eventually, enough people were persuaded to vote for the Constitution when there was a promise that they would ratify. The first thing that they would do is they would make a Bill of Rights, right? It lacked a Bill of Rights as the Constitution was written. So they said the first thing we'll do is we'll make amendments to it and add a Bill of Rights. Sam Adams eventually threw support behind it, and Massachusetts voted to ratify the Constitution. So you see Massachusetts there, the pillar is now standing up. And then they turned to other states. Maryland ratified it. South Carolina ratified it. Virginia, the next major state, right? This is a huge population state. And some of the heavy hitters, Washington, Jefferson, Madison, Patrick Henry, all from Virginia. So people were watching Virginia very closely. If you look on the far right, New Hampshire's kind of just started to really kind of get themselves in gear here. So the big question is what happens with Virginia? And if you look so far, 1, 2, 3, 4, we have 8 pillars upright. So we needed one more state to ratify the Constitution for it to become effective. And that 9th state was not Virginia. New Hampshire leapfrogged it. New Hampshire ratified it without too much conflict, while Virginia still debated it. And you could say at this point, yes, the Constitution is ratified. We are a country. 9 out of 13 states ratified it. However, a lot of people said that doesn't mean anything, because if Virginia and New York aren't part of this, then we're not a nation at all. Virginia and New York are 2 of the most populous states. They're 2 of the most influential states. They have to be on board for this to really mean anything. And you see in this next segment of the cartoon, Virginia now has ratified it. It's just like Massachusetts, the debate went on, and they ended up ratifying it on the promise of a Bill of Rights, and just barely by enough votes ratified the Constitution. And then you see New York, a similar thing there. New York was very much against it. Alexander Hamilton and John Jay argued very eloquently for it, and eventually they ratified it. So then we see the last couple of states, North Carolina. Actually, interesting, North Carolina and in Rhode Island, the last 2, they didn't ratify the Constitution until after the government was actually already in place. After Washington was elected, after Congress started meeting, North Carolina finally came around to ratifying it. Rhode Island waited 2 years. Think that Washington was elected president in 1788, and Rhode Island didn't ratify the Constitution until 1790. So Rhode Island, again, this state that just does whatever it wants, Rhode Island, they eventually did ratify it because at some point it just seemed stupid for them not to. But at this point, though, once Virginia and New York were involved, it was pretty much a done deal, and we have a nation, right? The Constitution has taken effect. We are a country, and people have rallied behind it. If you look at the last thing, here's a picture of the Constitutional Convention, and there was a little quote in the book you might have read that George Washington, you see sitting on the far left up on a chair in a raised, it's like kind of podium, has a sun behind him, and Franklin had wondered if he'd been looking at a setting sun or a rising sun on the nation, but when they finally made the Constitution, he decided it was a rising sun, that the country had a bright future. I just want to take one last thing and look at the Bill of Rights. Now, this doesn't get passed until after Congress takes place, but I think it's important to put it in here because this is what the Anti-Federalists demanded. They wanted a Bill of Rights. So this is one of the first things that Congress does after the Constitution is ratified and there's elections and people are sent to Congress. They get to work on a Bill of Rights. And the first 10 amendments, these famous ones that we're probably familiar with, are the list of rights that the Anti-Federalists wanted. Congress shall make no laws respecting an establishment of religion. Think about establishment of religion means no national religion. That we can't say Americans are Episcopalians, we're not Anglicans, we're not Puritans, we're not Catholics. There's no religion of America. But it also says we can't prohibit the free exercise thereof. So states can't ban people from practicing religion, or the country can't, the nation can't. They can't abridge freedom of speech. So you can say what you want without fear of being punished. They can't abridge your freedom of the press. They can't stop people from printing things. If you remember from colonial America, the Peter Zenger case was the first real triumph for freedom of the press, and they put that into the amendments, right? You can criticize the government. You can write things as long as they're true. You can't write lies about people that will ruin their reputation if they're not true, but you can print the true stuff about government and other things. You have freedom of the press. The people have the right to peacefully assemble, right? You can rally, you can protest, you can march in the streets. As long as it's peaceful and you're not causing public harm or panic, you have the right to do that. You have the right to petition government, right? To complain to government about your grievances. So these are important things. These are all things that they saw to some extent that that were threatened before they were a country by Britain, and they want to make sure that it doesn't happen again. The Second Amendment. You have a right to keep and bear arms. So this is one that's controversial today about what that actually means. But I think in their time, they were people that just defended themselves against the British. Prior to that, against the French. They're constantly defending themselves against Native Americans, against the Spanish who are still on their borders, and just for hunting and things like that, defending their homes. They saw it as essential for them to keep and bear arms, to have weapons. And some people say today this is. It means something different today than it did then. We're not going to get so much into that. That's more of a kind of a government class. But the Second Amendment, the right to bear arms. Third Amendment seems not so important to us today. It seems impractical, but to them it didn't. No soldier shall in a time of peace be quartered in any house without the consent of the owner, nor in a time of war, but in a manner that's prescribed by law. So it's kind of silly now to think about them saying that you have to house and feed soldiers today, but think about their experience. They had 2 quartering acts. It happened to them in their immediate past, so they want to make sure government couldn't do it in the future. The Fourth Amendment, a bunch of stuff in here. We can look at some highlights. The right of people to be secure in their persons, houses, papers, and effects, right? That you don't have to worry about someone searching your house. You can say your person, mean like your pockets and things like that, your papers and effects. So you can't be searched unless against unreasonable searches and seizures, right? So someone can't just show up and say, "I'm going to search your house just because I don't like you," or because before the Revolution, they wanted to search John Hancock's house, just hoping to catch him committing a crime, but with no evidence of a crime. They can't do this. No warrant shall be issued without probable cause, meaning that if the government wants to search your house, they have to have probable cause, meaning some reasonable suspicion or evidence, or maybe not evidence, but reasonable suspicion to believe that you've committed a crime. So if they want to search your house, they can't say, "Well, I think you're a drug dealer. You look like a drug dealer." They'd have to say, "Well, I've from tips from informants, or we have surveillance of you passing a package from one person to the other, whatever it might be, something that would give a judge reason to believe that, well, okay, it's probable that you're committing a crime, so we're going to let him search your house." But you have to get that search warrant. The Fifth Amendment. Nobody can be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So basically, a grand jury is that you have to have the law enforcement has to present evidence to bring you to trial. So they can't just say, look, we're arresting you for stealing cars. We have no evidence that you did so, but we're going to make you go through the process of a trial anyway. So you can't do that. You have to have some evidence to present to a grand jury. Say, here's evidence that's, this person did something. We're going to have a trial. And remember, you're innocent until proven guilty. But they need to present evidence to show that it's possible. It's logical that you may have committed a crime. Now we have to have a case for it. They talk about that no person shall be subject to the same offense to be twice put in jeopardy of life or limb, what they call double jeopardy. If you go to trial for a crime and you are found innocent, you can't be brought back to trial for that same crime on the same evidence because you've already been proven yourself innocent. Think about that could be abused otherwise. If I was a lawyer for the government, a district attorney, and I didn't like somebody, I could just constantly sue them, bring them to court over and over and over again until I got a jury that wanted to make you guilty. Well, unless there's new evidence or new crimes committed, they can't do that. So you can't be held twice for the same crime. You can't be compelled to witness against yourself. So they can't put you on the trial to make you say that you're guilty, right? That's when you hear people say, I plead the fifth. They can't make you testify against yourself. Second to last thing for this one, you can't be deprived of life, liberty, or property without due process of law. Meaning you have to go through the law into this judicial process, right? You have to have a hearing. You have to have representation. You have to be able to argue for yourself. So that's a whole due process of law. It can't just be taken from you because the government wants to. And then the last thing, no person shall be deprived of property taken for public use without just compensation. The government can't take your house just because they want to. They got to prove that it's for the public good and then compensate you for it. So if your house was in the way of a major dam that was needed for hydroelectric power or to stop flooding, they could say, you have to move. We're going to give you money for it. It's for the public good. But they can't do it just because they want to. The Sixth Amendment. All criminal prosecutions, the accused shall enjoy their right to a speedy and public trial, right? So I guess speedy is up to interpretation, but we can't arrest you for a crime and then you have guilt hanging over your head for the next 7 years while we postpone having a trial. It has to be in what's considered a reasonable amount of time. That could be months. If it's a really complex crime or a case, it might be, more than that. It might be a year or more, but it can't be, like 20 years down the road, we finally got around to it. It has to be a public trial. It has to have an impartial jury of the state and district where the crime was committed. So if you commit a crime in the seacoast of New Hampshire, there has to be a jury of people from this area that would be ruling your innocence or guilt. You have to be told what crime you're accused of. You can't just be thrown in jail and not told what crime it was. This is, if you remember from last semester from a study of European history, this is what we call habeas corpus, right? You have to be told the charges against you, and you can't be held without charges being pressed. You have to be confronted with witnesses against you. If someone accuses you of something, they can't do it anonymously. They have to reveal themselves. You have to have compulsory process for obtaining witnesses in his favor, right? So I can't be held for a crime and go to trial and then not be allowed to call people to testify for me. And I have to be given the assistance of counsel if I want it, right? So if I want to get a lawyer, they can't deny me the use of a lawyer. Amendment 7 is a similar thing. We're not going to spend much time on it. Basically talking about all things that are laws. This would be more like civil cases that are under a certain amount of money. They say $20 here. I can't remember what the amount is now. They've raised it now. I think it's like $5,000. But if you and me get into a dispute about something over, like I owe you money and it's less than $5,000, then we can have a trial without a jury. So that's basically talking about that, how to settle some matters like that. The Eighth Amendment, we can't have excessive bail, meaning that if you're arrested, if you don't know what bail is, if you're arrested for a crime, you're innocent until proven guilty. So let's say we arrested you yesterday, but your trial is not going to be for 6 months. Well, we can't keep you in jail for 6 months because you're innocent until proven guilty. If we kept you in jail, we'd be in a sense assuming your guilt. So you have to pay bail, which is basically you give money to the government to say that they're going to hold until you come back for your trial in 6 months. And when you show up for your trial, you get your bail money back. So basically, it's a way to ensure that you're going to come back for your trial. If you didn't show up for your trial, you would lose all that money. So they can't have excessive bail. So if you got arrested for jaywalking, not that would really be a trial, but let's say you got arrested for jaywalking, they can't make the bail $1 million. It have to be something more proportionate to the crime. Same thing with fines. They can't give you a $50,000 fine for stealing a candy bar, something like that. They can't have cruel and unusual punishments. That's open to interpretation. Today, we still don't really have it. There's not a clear understanding of what that is. Is capital punishment cruel and unusual? Some people say yes, some people say no. Is things like psychological deprivation, like when you have prisoners depriving them of steady meals and daylight, things like that, waterboarding, all those things that I'm sure everybody has opinions one way or the other, but this is up to interpretation. This doesn't say what cruel and unusual is, and that's kind of the genius behind it. Really, is that they maybe had a sense that things might change and people's opinions might differ, so. Leave it open to circumstances changing in the future, but no cruel and unusual punishments. The Ninth Amendment, important. They're basically saying that these rights that we just talk about, the enumerated rights in this Constitution, meaning the written down rights, these are not the only rights you have, right? There are other rights you have. Basically, these rights that they've said so far are the minimum you have, but you can have more rights, especially because states already wrote bills of rights. So some states might provide more protection than this federal government. So they're saying this is the least rights you have, but you can definitely have more. We might change this later. Your states might add other rights. And then the 10th Amendment was added in there to appease the anti-federalists too, because it protects the states. It says any power is not given to the United States by this Constitution, or powers that aren't prohibited to the states by the Constitution are reserved to the states and to the people. So basically it's saying, look, if the Constitution doesn't say the federal government can do it, that means the states can do it. The states have powers and rights. And it doesn't say specifically what they are, but it basically is reinforcing the idea that the states can do anything that the federal government wasn't said it could do. The Constitution didn't say the federal government can do, and they can do anything that the Constitution didn't expressly say states can't do. So that's the Bill of Rights, and this is very important. This gets ratified pretty quickly after the first Congress met, because the Anti-Federalists, that was a promise made to them. If they supported the Constitution, they would add a Bill of Rights. So that's where we'll end this video, and we'll study a little bit more of this stuff in the future, either this year or next year. But this kind of ties up the Constitution.